Did you forget to pay maintenance? In today's video, we talk about the obligation of maintenance. The duty to support and maintain a child is a common law obligation shared between parents. The obligation continues until the child becomes self-supporting. Are you aware that not paying maintenance in accordance with the court can follow you for up to 30 years? It was a bitter lesson for Simon Arcus when a Supreme Court of Appeal handed down judgment in the Arcus vs. Arcus 2022 and ordered him to pay 3.2 million rand in arrear maintenance after 25 years. Arcus argued that since a period of 25 years had lapsed and no maintenance payments were made throughout that period, the debt had become unforeseeable due to prescription. The Supreme Court of Appeal rejected Mr Arcus' claim, holding that a divorce order containing an undertaking for maintenance is a judgment debt, and as defined in Section 11 of the Prescription Act 68 of 1969, and it is not an other debt defined in Section 11 of the Act. An important distinction between a judgment debt and any other debt is that a judgment debt prescribes only after 30 years, whereas any other debt prescribes after 3 years. The Supreme Court of Appeal weighed several factors when coming to its decision, including the fact that no longer prescription period is in the best interest of vulnerable individuals, such as divorced women and minor children, who are the usual beneficiaries of maintenance orders. In order to avoid the hardships Mr. Arcus faces today, he should have fulfilled his maintenance responsibilities and followed the court orders as a citizen should. They asserted further that the defense advanced by Mr. Arcus would fly in the face of a maintenance act, and that this would be a mechanism for evading and eluding the purpose of this maintenance act. Thank you for joining us in today's video.